Okay, let's unpack this. In our increasingly digital world, data is absolutely everywhere, right?
Really is.
And for many of us, the idea of web scraping might conjure up, I don't know, images of shadowy figures quietly hoovering up information.
Yeah, that's a common image.
But with the rapid rise of AI, this practice has gone from being like a niche tech curiosity to a really mainstream and often deeply misunderstood legal and ethical tightrope walk.
That's a good way to put it. A tightrope.
So today, we're doing a deep dive into exactly what that tightrope looks like. And we're guided by some truly insightful and recent guidance that's maybe challenging some long-held assumptions.
Exactly. What's fascinating here is that we're looking at a focus sheet from June 19th, 2025. It's from the CNIL, that's France's Data Protection Authority.
Okay, the CNIL.
And this isn't just some dry legal document. It provides some really crucial clarity on the legal basis of legitimate interest when it comes to web scraping, specifically for data collection, especially in the context of developing AI systems.
Right, for AI training.
Precisely. So our mission today is really to cut through any jargon and help you understand the inherent risks involved, the mandatory measures data collectors simply must take,
The non-negotiable.
the non-negotiables, and maybe most importantly for many listening, how site publishers can actually protect their content.
Yeah, that's key. So whether you're a developer working with large data sets, maybe a business owner worried about your online presence, or just someone curious about what happens to the data you put out there.
Which is probably most of us now.
Right. You're going to walk away from this deep dive with a much clearer and perhaps surprising picture of the rules of the road.
Oh.
We'll try to pinpoint some facts that might make you say, wait, really? And give you enough clarity so you don't feel, overwhelmed.
Yeah.
So the common perception might be that web scraping is either like totally open season or conversely completely illegal. But this CNIL guidance suggests something much more nuanced.
It really does.
What's their initial stance here? What are they not prohibiting, maybe, and what are their immediate concerns right out of the gate?
You've hit on the core tension there. The CNIL isn't saying web scraping is prohibited per se. It's not a blanket ban at all.
Okay.
However, it absolutely requires a rigorous case-by-case analysis. What's truly critical is their emphasis on the significant risks. First and foremost, they highlight major concerns for privacy and GDPR rights.
Right, the big ones.
Think about the sheer volume of data involved, the vast number of individuals who can be affected, and the inherent difficulties people face in exercising rights like, say, the right to erasure once their data is scooped up.
It's hard to put the genie back in the bottle.
Exactly. And here's a big one. The serious risk of collecting private, sensitive, or even highly sensitive data, like detailed social network use. Or, and this is crucial data belonging to vulnerable persons, particularly minors, who demand special attention.
That makes total sense. The scale alone is daunting. But it's not just about privacy rights, is it? There's more to it.
No, exactly. Beyond privacy, there's the risk of illegal collection. This could infringe on intellectual property rights, for instance, or reuse data without proper individual consent where it's needed.
Okay.
And this is a subtler point, but I think deeply impactful, the effect on freedom of expression.
How so?
Well, the CNIL argues that this widespread kind of generalized harvesting can create a feeling of surveillance
Right.
that might actually lead internet users to self-censor. Imagine you're hesitant to post something because you're worried about where that data might end up, how it might be used by an AI.
Yeah, I can see that.
That's a real concern, especially when using online platforms is now, for most of us, let's face it, a daily necessity.
Sure.
The broader context here is that these harvesting practices have fundamentally changed how we interact online. Almost all online data is now susceptible to collection and reuse in ways we might not even consider or haven't consented to.
Okay, so it's clearly a minefield of potential issues, from privacy to IP, even potentially chilling our freedom to speak online. But if it's not strictly forbidden, what's the primary legal ground most data controllers are standing on for this kind of collection, particularly for something big like training an AI model?
Most often, the legal basis they try to rely on for collecting publicly accessible online data for training databases falls under legitimate interest.
Okay, legitimate interest. But I sense a but coming.
There's a big but.
Yeah.
It's heavily contingent on meeting very specific conditions, all designed to limit any harm or infringement on rights. It's not a free pass.
Right.
And it's also really important to be aware of the risk of undermining other existing regulations, things like a website's general terms and conditions of use, or the specific rights of database producers, or even basic copyright.
So it interacts with a lot of other rules.
Absolutely. Now, there's an interesting specific exception for text and data mining under the Intellectual Property Code. That's Articles L122-5 and ANAT 12253 in France, which applies to research organizations.
Ah, for research.
Yes, but only provided the author or rights holder hasn't appropriately objected. So it's still a pretty narrow lane.
Got it. So for those looking to collect data via web scraping and trying to rely on this legitimate interest, what are the absolutely non-negotiable, mandatory measures they need to implement to even begin to navigate this legally? It sounds like the burden is heavily on them.
It absolutely is. Under the GDPR's principle of data minimization, that's Article 5.1.c, data collectors have very clear obligations. First, they must define precise collection criteria upstream before they even start.
Before scraping, okay.
Then they need to actively filter out any data that isn't strictly necessary for their specific stated purpose. For example, if you're collecting text for language model training, you probably don't need bank transaction data or precise geolocation data that might get swept up.
That sounds critical. What if filtering specific types of data isn't really practical, though? Like if it's all mixed together on a site?
That's a good question. If filtering specific data points isn't feasible, the guidance says they're then obligated to exclude entire site types that structurally contain sensitive data or data concerning vulnerable persons.
So exclude the whole source.
Right. Think about sites mainly used by minors or websites that are naturally sensitive by their topic, like certain health forums, maybe political affiliation sites, or some specialized online communities.
Okay.
Furthermore, any irrelevant data that is collected, perhaps accidentally despite these criteria, must be deleted immediately upon collection or as soon as it's identified as irrelevant.
So quick deletion.
Very quick. For instance, if you collect usernames or pseudonyms from a public forum when you actually only needed the content of the comments for analysis, those pseudonyms should be immediately stripped out and deleted.
Okay.
And here's a really crucial one. They must respect opposition protocols. This means automatically excluding from collection any sites that clearly signal they oppose harvesting via technical means.
Like what kind of technical means?
Well, the classic one is the robots.txt exclusion protocol, but also things like CAPTCHA, the completely automated public Turing test to tell computers and humans apart.
The squiggly letters test.
That's the one. Those are specifically designed to require human action and therefore prohibit automated robot access. If those are present, scrapers have to back off.
That's a pretty clear roadmap then. And it certainly places a significant burden on the data collectors to be precise and respectful of signals.
Absolutely. The onus is squarely on them.
But what about the other side of this equation? Let's flip it. If you are the one publishing content online, your blog, your company website, your community forum, how can you arm yourself against this kind of data harvesting, especially if you're worried about it being used for AI training?
That's a vital question for creators and publishers right now. And while it's true there aren't universal sort of legally binding standards yet for every single type of objection signal,
It's still evolving.
it's evolving fast. But site publishers definitely have various means available right now to signal their opposition. We can broadly distinguish between, say, blocking measures and non-blocking measures.
Okay, blocking first.
Blocking measures are about technical prevention. So implementing TTCHA is a direct block. Or employing IP address blocking that involves analyzing HTTP request headers, maybe monitoring the number of requests from one source, detecting suspicious IP addresses based on location or ISP, and maybe even maintaining a register of known scraping bot IPs or common VPN exit points.
So actively identifying and stopping them.
Exactly. Publishers can also use more advanced bot detection methods that try to uncover bots hiding behind requests that mimic browser APIs.
Interesting. Okay, so those are the direct barriers. What about the signals? The ones that communicate your wishes without necessarily putting up a technical wall.
Right. Those are the non-blocking measures, which act more as signals and protocols for well-behaved collectors to follow. The traditional robots.txt file is still absolutely key here. If you put disallow for AI bots, legitimate scrapers should respect that.
Still relevant then.
Very much so. But newer exclusion protocols are emerging too, specifically aimed at AI. You might hear about things like AI.txt, which was proposed by Spawning AI, or TDMRep that uses a TDMRep.json file and comes out of work at the W3C designed for text and data mining objections.
New standards developing.
Exactly. Other methods include things like dynamic page loading, which limits the amount of raw HTML content easily accessible on the site at once, or using specific meta tags in your website's code, like DeviantArt did with their NOI or Noimi tags.
Giving signals within the page itself.
Precisely. There's also the option of registering your domain in an objection registry, like some do not train lists that are popping up, to signal broad opposition to collections, specifically for AI model training.
So, multiple ways to signal no.
Yes, and the CNIL actually encourages organizations, both publishers and collectors, to participate in standardizing these interoperable opposition mechanisms and to comply with new emerging standards. But here's the key takeaway for publishers listening. The CNIL guidance makes it clear that data controllers are legally required to respect robots.txt and KPT-CHA. So, if you want to protect your content using those memes, you must implement them.
That's a powerful message. It shifted from just hoping they won't scrape to having recognized methods they have to respect. It's not just a passive situation anymore. You can actively signal your intentions and put up recognized barriers.
Exactly. It empowers publishers to some extent.
Okay, but let's take a tricky scenario. What happens if, despite all these filtering measures and respect for signals, an organization incidentally collects some sensitive data they really weren't looking for? Does that immediately make the whole process illegal, or is there some grace for an honest mistake?
That's a really practical question. Generally speaking, the incidental, unsought collection of sensitive data is not immediately considered illegal in itself. The Court of Justice of the European Union, the CJEU, has actually acknowledged this reality in a ruling.
Okay, so accidental collection isn't an automatic violation.
Not automatically. However, and this is the critical point, if the organization becomes aware that it's processing sensitive data, and especially if they are notified by the data subject whose sensitive data it is, they are then required to delete it immediately and automatically as far as technically possible.
So awareness triggers an immediate deletion obligation.
Yes. Now, there is an important but very narrow exception. Processing sensitive data can be authorized if that data was clearly made public by the data subject.
Okay, clearly made public. That sounds like a high bar.
It is an incredibly high bar. It requires explicit, clear, affirmative action from the individual based on a fully informed configuration choice with the genuine intent to make that specific data accessible to the general public. It's not enough that it was just technically accessible somewhere online.
Right.
As the CJEU stated in the Meta Platforms ruling, it's really about whether the individual wished to make it public, demonstrated through their actions. Not just that a scraper could find it.
That distinction is crucial. Okay, here's where I think it gets really interesting. We've discussed the technical requirements, the legal bases, the signals, but there's this deeper, more human layer to it all. It's about what people expect when they put information online. So when the CNIL talks about reasonable expectations, what does that actually mean in this context, especially in a world where AI is constantly consuming data?
That's a vital concept, you're right, and it's where the nuance truly comes in, beyond just the technical rules. Data controllers must limit the infringement of rights by actively considering individuals' reasonable expectations.
So how do they figure that out? What factors play into it?
Well, the CNIL points to several factors. First, obviously, is the data actually publicly accessible without needing logins or special permissions? Then you need to consider the nature of the source websites themselves.
Like, is it a personal blog versus, say, LinkedIn?
Exactly. Or a very public news site versus a closed online forum for a specific hobby. Or maybe a site specifically set up for distributing data sets. They all carry different expectations. Any restrictions those sites impose, like terms and conditions, or those technical measures we discussed, robots.txt, CHAs, are also critical.
Good.
In fact, the CNIL explicitly states that processing won't meet reasonable expectations if sites that clearly oppose harvesting using those standard methods are not excluded from the collection.
So even if I could technically get the data, if the site owner has put up a no-entry sign like robots.txt, my reasonable expectation of being allowed to use that data effectively drops to zero.
Precisely. Ignoring those signals is a big red flag regarding reasonable expectations. The type of publication also matters a lot. An article on a freely accessible public blog carries a different expectation than, say, a post on a social network profile that has access restrictions enabled, even if some wider audience can technically see it. The user might still reasonably consider that semi-private.
That makes sense. The context of the sharing matters.
It does. And finally, the nature of the relationship, if any, between the data subject and the controller collecting the data is also relevant. Overall, the CNIL acknowledges that while people might be generally aware today that data can be accessed online,
We kind of know it's out there.
right, But that general awareness doesn't mean people reasonably expect their data to be collected and reused in all situations, or for all types of data, or by anyone for any purpose, especially large-scale AI training they never envisioned. This awareness has certainly evolved with big data and AI, but it doesn't just grant carte blanche for collection. Reasonable limits still apply based on context.
Okay, that's a really helpful clarification on reasonable expectations. So, thinking about going above and beyond the mandatory measures we've already covered, and keeping those reasonable expectations firmly in mind, what are the additional guarantees the CNIL encourages data controllers to implement? The things that would further limit infringement of individual rights and freedoms. What would truly set an organization apart as being more responsible?
These additional safeguards are highly recommended by the CNIL, and their relevance really depends on the specific intended use and potential impact of the AI system being developed. They're not necessarily mandatory in every case, but strongly encouraged.
Okay, like what?
One suggestion is establishing a default exclusion list. This would be a list of types of sites whose collection would be excluded by default, especially those known to contain particularly intrusive or sensitive data.
So, proactively deciding not to scrape certain categories.
Exactly. Think about maybe pornographic sites, specific sensitive health forums, or perhaps highly detailed genealogical sites that contain family information. Another recommendation is to explicitly respect objections from sites that oppose harvesting their content specifically for AI training databases, maybe through technical signals or even legal measures like their user-generated content UGC agreements.
So, going beyond just the basic robots.txt and looking for more specific AI objections.
Yes, acknowledging those newer signals and terms. Another key guarantee is to try and limit collection only to freely accessible data, meaning content accessible to any unregistered user without needing an account.
So avoiding anything behind a login or paywall.
Precisely. This would specifically exclude data from, say, private social network profiles or closed groups, or data from petition sites where the public nature isn't immediately obvious unless you're logged in.
That feels like a significant limitation.
It can be. Wider information dissemination is also strongly encouraged. This means actively informing individuals about the data collection and their rights through multiple channels, maybe online articles, social media posts, perhaps publishing an updated, accessible list of the sites that have been harvested.
Being transparent about sources.
Exactly. And the CNIL notes that good practice includes trying to disseminate this information through the original site publisher where the data was collected, if feasible.
And what about empowering the individual even more directly? Any suggestions there?
Absolutely. The CNIL also recommends providing individuals with a right of prior discretion and opposition where possible. They encourage exploring technical solutions like maybe push list mechanisms where individuals could proactively opt out before data collection even happens, rather than trying to get it deleted afterwards.
An opt-out registry, maybe.
Potentially, yes. Or ways for controllers to respect individual opposition before the scraping starts. And whenever possible, applying anonymization or pseudonymization processes immediately after data collection is a strong guarantee.
Masking identities quickly.
Yes. And finally, preventing identifier cross-referencing is crucial. This means, ideally, replacing individuals' identifiers, like usernames, with random pseudonyms per content piece, not consistently per user across all their content, unless there's a clearly demonstrated and justifiable need to aggregate different data points from the same person for the specific AI system's development.
That sounds technically complex, but important for privacy.
It can be, and the CNIL gives a specific example to illustrate this. They say, for instance, an organization collecting numerous online voice recordings to develop a voice generation tool, but doing so without implementing any of these additional guarantees to protect the training data or limit the risks of illicit reuse. That organization cannot simply rely on legitimate interest as their legal basis.
So the lack of safeguards can invalidate the legal basis.
Correct. Ultimately, the CNIL stresses that the data controller is responsible for judging the relevance and necessity of implementing these additional measures on a case-by-case basis, depending on the risks involved.
Wow. It's really clear this isn't a set-it-and-forget-it situation at all. It really paints a picture of just how much responsibility falls on data collectors now, doesn't it?
It really does.
It requires constant vigilance, ongoing assessment, and genuinely proactive measures to minimize harm.
Yeah, absolutely.
What a journey that was. Into the complex and honestly often surprising world of web scraping, AI development, and data privacy. What we've really unpacked today, I think, is this incredibly delicate balance between innovation, the drive to build these powerful AI tools, and the fundamental rights of individuals to have some control over their digital footprint.
That's the core tension, isn't it? It's a rapidly evolving landscape where legitimate interests, however valid they might seem for innovation, must always be carefully weighed against those reasonable expectations of privacy we discussed.
Yeah.
And if we connect this to the bigger picture, it truly highlights how the lines between what we consider public and private online content are becoming increasingly blurred, maybe even meaningless in some contexts.
It's a sobering thought.
This guidance from the CNIL isn't just about ticking legal compliance boxes. It really pushes all of us, developers, companies, users, to think critically about every piece of data being collected, why it's being collected, and what its potential impact might be, not just on the individual, but on society at large.
So think about the listener. What does this all mean for you? As AI continues its, insatiable hunger for data, and our digital footprints inevitably continue to grow. Maybe consider this. Beyond just the technical protocols like robots.txt and the legal frameworks like GDPR, how do your own evolving reasonable expectations about online privacy shape the future of data collection? And perhaps what role can you play, whether as a user, a creator, a developer, or just a citizen, in advocating for, or maybe even helping to develop, solutions that genuinely empower individuals in this new, fascinating, and frankly, slightly scary digital frontier?